live stream on one judge and then call.
Okay.
Let me just I'll put my video on. Hang on, wait until I've done that.
Appeal but heard in the matter of Dell and another and the Secretary of State for Work and Pensions.
Good morning.
Good morning.
Before we start, can I remind everybody again who's on this session that everybody must mute their microphones and turn off their videos unless they are counsel who is speaking to the judges, and of course unless they're one of the judges themselves. So would everybody please check their videos and their microphones and ensure that they are off unless they are the counsel addressing the bench. So James, you were addressing us yesterday.
My Lord, my Lady, the only person I can't see at the moment is Lady Justice Rose.
Well, I can't see her either, but I don't quite know what. I know she's here. She's definitely.
Yes, I can see myself. I don't know why. Let me switch.
There you are. You're now. You're up now.
It's the usual.
Oh, you've gone.
You've gone again.
You were there and then you went. Yes, that's it. Thank you.
My Lord, my Lady, I've done the approach to justification. We're within age discrimination still, and the submissions I was going to move on to have the heading: the judgments were plainly nothing like, manifestly without reasonable foundation. And the starting point for the purpose of these submissions is the correct approach that the appellate court should take. And the point can be made shortly. The submission is that the appellate court doesn't second guess the first instance court's assessment of justification. Its function is the traditional one of review, so it's not enough that its conclusion would have been different. The lower court's decision must be wrong. And again, that will be very familiar to my lords and my lady. I take that analysis from Lord Carnworth in the R case, R, the Chief Constable of Manchester Police. Again, I don't suspect you need to turn it up. If you wanted, it's in the Bundle of Authorities, Bundle 3, at tab 43, and the relevant paragraph for present purposes is paragraph 65 in the judgment of Lord Carnworth. And my submission is that the Divisional Court's assessment of justification here was plainly not wrong, and indeed plainly right. For detailed explanation of the sorts of considerations and issues that Parliament had to weigh are set out at very considerable length, and apologies for that, but I suspect that the Divisional Court has probably done most of the heavy lifting in terms of that statement in the statement of Mr. Gilchrist, which I know you're aware of, it but not its exhibits. I think only one of the exhibits, the white paper that preceded the 1995 Act, has made it into your bundles, because all you need is from the Divisional Court's judgment, and if you want it in the raw, from the statement of Mr. Gilchrist, which is in the supplementary bundle at tab 1. But even a cursory read of that statement indicates, we submit, the scale, complexity and nature of the issues and balances that were involved and that had been involved in the successive pieces of legislation that have affected this area. In terms, just to flick through the analysis of justification, in terms of the legitimacy of the aims, we submit that the Divisional Court was plainly correct to summarise them as they did in paragraph 53 of the Divisional Court's judgment. In essence, equalisation, a positive and beneficial aim to equalise the position between the sexes, to do so over time, precisely to allow time for adjustment and therefore in a graduated manner. And this point about the timing of increases in the state pension age for women to get to equalisation is obviously inseparable from the fact of those increases. So equalisation and an increase in the state pension age as a second legitimate aim when the clock started moving up, as it were, from 65 to 66 and so on. And that is essentially on the basis of, or with the aim of, making the pension system work economically. They've got to be affordable. That ultimately involves striking the appropriate balance between the state pension age and the size of the state pension. You've got a whole bunch of societal trends that are working, as it were, against the pension system, with people living for longer, and the additional issues that brings to bear in relation to intergenerational fairness. But those were the essential aims, and we respectfully submit there can't be any doubt about their legitimacy. In terms of necessity and proportionality, you have the detail of the chronology and the thinking over time, and in relation to each of the various steps that fed into the legislation, became the legislation, in Gilchrist 1, the first Gilchrist statement, supplemental bundle, quite a long chunk for that purpose, between paragraphs 25 and 130. But again, the overarching submission in relation to necessity and proportionality, apart from that the Divisional Court got it right, it is that when you consider that the nature of the individual strands of reasoning feeding into these multifaceted legislative decisions and how they all mesh and balance together, it becomes quite clear that these are judgments which Parliament only could sensibly make. You've got a series of interlinked decisions, all with their own complex balances underpinning them, and all affecting the other strands of decision making. So you've got decisions about whether to equalise, to what age are you going to go if you are going to equalise, how quickly and phasing you need to get to the place of equalisation. Do you do it all in one go? Do you do it that way with a cliff edge, as it were, or do you stagger it? Once you equalise, what should the ultimate state pension as equalised be? Should it be 63? Should it be 65? Should it be 68? And how quickly should any increases take effect? Fundamentally, Parliament evidently wanted to equalise on societal grounds, essentially, on the basis that it's not acceptable in the modern world to have men and women with different state pension ages. It runs directly counter, it might be thought, to modern principles and modern laws promoting equality. The reasons given for the original decision to alter 65 for both, the reasons given for that original alteration, with the drop having been created in the 1940s, as you will recall, see Gilchrist 1, paragraph 14, when the state pension age for women was reduced to 60. With the greatest respect to history, they look rather old-fashioned in terms of reasons now, but the reasons for dropping that age down to 60 in 1940 have long gone, it might be thought, and the reasons for moving from the historic position to the more modern position are perhaps crisply summarised in the 1993 White Paper, Supplemental Bundle, tab 5, page 150, where it was put in this way. It was said there that preferential pension age for women has no place in this modern context. There is no reason for a woman to receive an earlier pension than a man if they both paid the same contributions, which is at least one of the comparator points. And then you have a question, or a set of questions, around how quickly and to what age. You could bring the men down, you could do it to various ages in theory, but those questions themselves raise complex issues and judgments for which there is no right or wrong answer, but merely a balance and a judgment for Parliament. There's nothing wrong with wanting to equalise quickly on social grounds, and of course the longer it takes, the longer the direct discrimination on grounds of sex is perpetuated. And the longer it takes, the more serious the effects on both intergenerational fairness and getting to grip with the economic aspects of state pension provision in a society in which age expectancy and life expectancy have gone up, and gone up considerably. And you have in addition a series of other factors affecting decisions about speed and what age. To take perhaps three of them. Firstly, living longer. So a pension is being paid for longer for both men and women, although the life expectancy figures differ as between them. So if you perpetuate women at 60, you build in the longer term economics associated with that, particularly in circumstances in which people are living longer. And just to give some flesh to the bone of these submissions, if you go to Mr. Gilchrist's statement, if you've got the supplementary bundle to hand, and you go to paragraph 79 in relation to living longer, just by way of example of these sort of things, you've got a pretty telling statistic by the time you reach 2011, and the white paper sets it out, the white paper that preceded the 2011 Act. If you look at the second half of paragraph 79, beginning with the bit that says, as the 2010 white paper set out, and I just invite you to flick an eye over that quotation to the end of the paragraph. So living longer is a factor of obvious importance in terms of how quickly and to what age. Intergenerational fairness I've referred to on a couple of occasions. That arises because the nature of the funding of state pension is it is a pay-as-you-go system, as Lord Hoffman pointed out in the Carson case. So affordability is inextricably intertwined with this issue. The question in broad social and economic terms is what burden, in effect, to fund the people who are in receipt of state pension can and should be imposed on the working population, who fund it by way of contributions into the NI system, the National Insurance System. And that raises all the questions that are considered by Mr. Gilchrist about the ratio of working people supporting pensions altering. There are, in a nutshell, as he points out in his evidence, see, for example, paragraph 30, fewer working people supporting each pensioner, and by the way, because they're living longer, each pensioner for longer. So at paragraph 30 he gives the statistics, 3.4 working people supporting on pay-as-you-go system each pensioner in 1990, down to 2.6 per pensioner in 2050 predicted. So you are effectively increasing and significantly increasing the burden on the next generation. And note that all cost is not abstract here. It goes directly to this. Moral that you have to fund for a longer life expectancy, and the moral the burden has to be borne. And that's the third point then, to come to it, that's potentially a very, very big burden. In 1995, the judgment was that public expenditure on pensions was set to double between 1991 and 2030. So it's a doubling that has to be borne by today's and tomorrow's taxpayers. And if affordability is a real and pressing issue, as it plainly is given that life expectancy has increased so much, the speed of equalisation has an impact on affordability. The core reasons for the decision to equalise to 65, just to take that as a judgment, were given in the white paper in 1993, quoted in Mr. Gilchrist at paragraph 36, and summarised or quoted, and I think that's probably all you need by way of reference, in the judgment at paragraph 14. And of course, each of these themes feeds through into the debates and the enactments that subsequently occur, including in 2011, the decision that on the basis of how all those factors looked at that point in time, Parliament decided that there was a need to accelerate the increase in state pension age for men and women, and to speed up the process of equalisation. So it had to be done and completed, was the judgment, by 2018 rather than 2020. So you've got a whole bunch of issues feeding into the how quickly and to what age set of decisions. And then finally you've got a set of questions relating to the fairness, to those whose state pension ages are being increased as part of equalisation. How much notice, the extent of the effect, and so on. And that's not a straightforward question in its own right. You can't just take from the fact that state pension age for them was being increased. You can't just take that in isolation. And if you stagger the increase in state pension age to get to equalisation, it's inevitable that some women will fall on one side of the line and others on the other. But the fundamental aims of the way in which it was done, just to make 4 brief points in relation to the way in which it was done and the impact therefore on the fairness to those who are affected. First, there was a legislative decision to stagger or to phase equalisation over a period of time, what the Divisional Court referred to as the taper. And the core aim of that was to allow a period of notice before the changes cut in, to allow at least some period of time for adjustment and preparation by those affected. If you're born later, your working life starts and ends later. That fact, rather than the mere difference of age, is what is important to the aim of allowing notice during the working life in a way that is, in inverted commas, fair. And of course there is no binary answer to the question, how long is enough? It's a judgment for Parliament, but it is plain that the period that Parliament allowed was a significant one. 1991 was when Barber was decided, and then there were announcements and the Green Paper on the intention to equalise, Gilchrist 1, para 28. 1993, the Chancellor said that there was an intention, a governmental intention, to equalise to 65, Gilchrist 1, paragraph 35. And then 1995, the Act was passed and had effect pursuant to Schedule 4, in effect from the 6th of April, the beginning of the tax year in 2010, with a period of equalisation staggered over 10 years to 2020. So at that point you had a minimum of 15 years running to 20 years notice, if that's how you want to view it, subsequently shortened to 2018 for completion in 2020 in the 2011 Act. But the fundamental point is that these involve questions of judgment. You could, no doubt, in theory, have set the period of notice in 1995 in effect at 25 years, but that involves a trade-off. You get more notice, but the direct discriminatory effect is perpetuating for another 25 years. Or you could say, well, it should be 10 years, or 15 years, or 5 years. These are simply unanswerable questions, other than by making legislative judgments. That's the first one, about staggering or phasing the equalisation over a period of time. The second point to bear in mind is that you graduate in that way, essentially to make the cliff edge not a cliff edge, but a slope. That's the whole idea of this. Thirdly, of course, you need to recognise that phasing or staggering and affording notice in that way has got to be balanced against a serious set of issues: social, because it involves prolonging the current inequality in the state pension age; economic, because if you shorten it or lengthen it, that has direct and very, very significant economic effects; and societal, because those economic effects bear on intergenerational fairness, having regard to the way in which the state pension system is funded. The fourth and final point to make in relation to fairness, overall fairness or disadvantage to the group of women born in the 1950s, is that, as Mr Gilchrist points out in section D of his witness statement, see paragraph 9 by way of introduction, and then the long passage between 131 and 174, it is far from clear-cut, any unfairness or disadvantage that is asserted. The key conclusions and analysis of Mr Gilchrist, it might be thought, are those between paragraphs 131 and 133. And it's a very, very complicated question to work out whether they are truly disadvantaged, because you have to make judgment calls about the metric. In terms of just focusing on 3 areas for that purpose, life expectancy and intergenerational fairness, women, as Mr Gilchrist points out, at 134, can expect to live longer by an average of 2 years compared to men, and thus will receive 2 years more state pension than men. Life expectancy generally has surged, so everyone will receive pension for longer than previous generations. That's now slowing, so the next generation funding this one will not have the same extra benefit. But that set of issues complicates and raises questions about the true fairness or unfairness of equalising in this way, or equalising at all. See Gilchrist 137 to 138. So far as employment is concerned, employment rates for women born in the 1950s have increased year on year, and employment rates for women aged between 60 and 64, in other words, born between 55 and 59, have seen the strongest growth of any age demographic since 2008. And the gap between employment rate for men and women between 60 and 64 has shrunk from 23% in 1998 to 12% in 2018, Gilchrist 141 and 147. So we've got life expectancy, intergenerational fairness, employment statistics, wealth generally as the third of the features here. Women born in the 1950s have greater wealth, both than previous generations and the cohort born in 1961 to 1965. And they'll also benefit from defined benefit occupational pension schemes not available to later generations. See Mr Gilchrist 148 to 158. The greatest housing wealth is held by those born after 1966, Gilchrist 166 to 168. And those born in the 1950s have seen significant income improvements over previous generations.
I'm sorry, could you go back just a second? You referred to the greatest, is it property wealth?
The greatest housing wealth.
Was for those you said in the 1960s?
Born before 1966.
Oh, before 19, I'm so sorry, I didn't get the word before.
Yes, I'm so sorry, my lord.
That isn't therefore specific for the cohort we're interested in.
It isn't. But what Mr Gilchrist is trying to do is to see what metric you might use and then do a broad comparison. And his conclusion is a measured one, I respectfully submit, as the Divisional Court noted. It isn't to start making a positive case. It is rather to say it's really extremely complicated to work out whether they are truly disadvantaged. It depends on the metric you take. Here are a bunch of metrics you could take, some of them more or less exact, but they all tend to the same point. And as I say, the purpose for going through this exercise, which I now conclude, is not as it were to make a positive case there, but to simply to indicate, and this is really the punchline of it, that these are matters of judgment, not of empirical proof. There are a very complex set of factors. There are complex relations between those factors. There is a variety of issues and interests in play that need to be balanced. And it is simply not tenable to say that the legislative judgments that were struck against that backdrop were manifestly, or anything approaching being manifestly, without reasonable foundation. And all of that, we submit, was carefully analysed, very carefully analysed, having obviously spent an enormous amount of time working through the detail in the evidence presented to them by the Divisional Court, back to the fundamental test for you as an appellate court set out by Lord Carnworth in R. My learned friend Ms Hill said, well, they might have applied the wrong test. They didn't ask the Wilson question, if I can put it that way. You'll remember that passage that she quoted in her skeleton from Lord Wilson in DA. Why is one group disadvantaged over another? And here you've got to do the right comparison, as we discussed at the end of yesterday. Here the comparisons between the earlier age group pre-change against those subject to the change. But that, with the greatest respect to her, is exactly what the Divisional Court focused on in their judgment between paragraphs 53 and 55 in particular. They were looking exactly at the effects on those on whom the changes bit, as one sees in particular from paragraph 54 of the judgment. And of course the context for this is that it's all about whether it's justified to treat the 1950s women less favourably than those born earlier, upon whom the changes didn't bite, or whether because of their particular economic and social situation the change should have been postponed so it bit upon a later generation. That's what the analysis is all about. And below the claimants say, well, it wasn't justified to impose the changes on women born in the 1950s because of their particular situation, or that if the change was going to bite on them, it should have been softened in some way. And the court weighed up all of that evidence, looked at that issue, applied the appropriate margin of discretion, which it had to, and decided that it was justified. See paragraph 54 of the judgment. And the reason for changing engaged all of the factors bearing on an issue of this kind, specifically whether there should continue to be disparate state pension ages. See judgment paragraph 53. And they also dealt with the specific arguments that were advanced below and appear to some extent to still be advanced about whether some other compensatory measures should have been made. In other words, you don't not alter the state pension age, you allow that to equalise, but you award some other compensatory measure based on the allegation of harsher effects. Well, again, the court below dealt with that argument in paragraph 54. And in terms of the evidence on which that set of judgments was reached by Parliament and then by the court in considering the issues, in terms of the evidence, it wasn't just about the strength of the policy reasons for making the change to 65 and about the reasons for the timing of the change. The respondents' evidence also covered the particular economic situation of 1950s women vis-à-vis earlier and later generations in a fair amount of detail, as you've seen, and explained why they were supposedly, why the suggestion that they were supposedly in a particularly disadvantaged position was at least simplistic. And I've given you the various references to all of that in terms of the fairness and the way in which that's a complicated question in the submissions I've just made by reference to Gilchrist 131 to 174. So we respectfully submit that the approach of the court below was correct in principle and did not, on any view, fail to focus on the right question, if the right question is what is the explanation for the difference of treatment. I say if that is the right question, and I simply put down this marker, I suspect it might well be the right question in relation to age discrimination, but there is at least a potential complication about the focus of justification in circumstances where the allegation is that you're not dealing with direct discrimination, but you're dealing with indirect discrimination, precisely because indirect discrimination starts from the premise that there is an apparently neutral measure that appears to have disparate effects or impacts. I don't think there's any need to get into that set of issues that there is at least a question as to how you approach justification and what the focus of justification is in that sort of situation. And the reason is obvious, because if you're starting from the premise that you've got an apparently neutral measure which has disparate effects, your focus should be, or at least should be in significant part, on the justification for the measure itself. That doesn't necessarily exclude something like the Lord Wilson question coming in any event, but it does raise the question about the focus of justification. As I say, there's no need to get sucked into that issue, but I simply flag it for the court, because I'm sure you will have read in the past the SG case, in which Lady Hale addressed exactly this issue. She reverted to it in the DA case as well, I think. But her analysis in SG, which I don't think is in the bundles, but if you need it, it's the SG and the Secretary of State for Work and Pensions, and it's her judgment in paragraph 189, effectively making exactly the point that I've just made, which is that if you start from the premise that you're dealing with an apparently neutral measure, then there's a greater focus perhaps on the justification for the overall measure itself, rather than the difference of treatment, because by definition, the PCB or the legislation, if you translate that into here, it is applying equally. So it's a slightly strange premise for reasons which you'll understand and which I will revert to in the context of sex discrimination here, where there's a prior question about the nature of that discrimination in the first place, and whether it truly can be analysed as indirect discrimination, because it affected only the women. And so whether it's direct or nothing, but there's a set of complex and strange questions there. But if you do get to indirect sex discrimination, I simply put down the marker that there's a question about where the primary focus of the analysis lies. But that's what I want to say about justification and age discrimination. But perhaps having done that, can I circle back to Ackerman and to the points that we were discussing yesterday, and the point that my Lord Justice Underhill invited us to look at again overnight. And circling back to Ackerman, I made yesterday, and I don't repeat, the sharp point, if I can put it that way. If you want the relevant paragraph in your heads again, it's behind tab 12 of the authorities bundle, and it's that paragraph on page 7, as you will recall. As I say, I made and don't repeat the sharp point about that second paragraph on page 7. And as you'll see, and you'll recall, the sharp point that I made, if I'm allowed to describe it that way, involved not reading the sentence that my Lord the Master of the Rolls identified, not reading that in isolation. The reason that they, in that case, had not established that their own situation was comparable was precisely because it has to be taken into account. In other words, the sentence that follows that. And then, accordingly, they can't claim equal treatment in time. That was the totality of the reasoning, and it was sufficient to dispose of the question whether they were discriminated against on grounds of age. But even if you are dealing with the establishment that the situation is comparable as it were, a factual exercise, as the judgment there recognises, it's for the applicants to do that. And at the very least, even if it isn't sufficient as reasoning, in other words, even if the sentences that follow that one are sufficient and complete as reasoning, it follows that they are evidently very, very important in terms of any sort of factual, non-absolute analysis of that sentence. And here, there is nothing, i.e. in our case, there is nothing to contradict the reasoning that follows on the facts. On the contrary, we submit, all of the facts are against comparability, essentially for all of the reasons that Parliament took into account in deciding whether or not to make the change to equalise the SPA. And of course, when one gets into that place, you note that those sorts of issues collapse very quickly into the question whether Parliament was entitled to equalise. And that may well be why it's acknowledged in the Strasbourg case law that although they are analytically separate, as Lord Hoffman, for example, was very concerned to point out in his analysis in the Carson case, there is plainly a substantial and often a very substantial degree of overlap, if one takes it in terms of the Strasbourg analysis, between the question of justification which sits at the end and the prior question of whether or not two groups are truly to be treated as being in an analogous situation. So I hope that makes clearer than I did yesterday, the answer that we give to my Lord's concern, which I entirely understand why the concern is raised about the sharpness of the principle and whether there is some alternative, but that is the analysis that I invite the court to consider in relation to that paragraph. We've been back overnight and reread, as I'm sure my Lord Justice Underhill has, the Ackerman judgment to see whether there is anything more from having read all of the words in the judgment, as I think you put it. And I'm not sure there's a great deal more clarity, and I'm not sure the answer I gave you yesterday needs to be altered to any significant degree. The complaint that the individual in Ackerman was less favourably treated than earlier generations seems to be because from a certain point contributions made to the German compulsory insurance scheme were not simply used to pay pensions, but were also used to finance other things, including the costs incurred by German reunification. So generations pre-1990 would have done better. And one gets that, at least as the basic idea, from the top of page 2 of the report, I think. But that's as far as we go. I don't think there's an identification of the precise legislative provisions that did that. You don't have a section of the judgment that says, here are the domestic law provisions that achieved all of these things. And it's undoubtedly to be recognised that there were scattergun complaints, but just zooming in on that one as the relevant one, that's the best that we've been able to do on a reread of Ackerman to seek to assist on that point.
Thank you very much.
Well, I was going to turn to my lady, I was going to turn to indirect sex discrimination then as the next heading.
Before you do that,
Yeah.
you slightly lost me at one point, Sir James, when I think at the very end of your analysis on justification, you brought into the issue what the complications from indirect discrimination as opposed to direct discrimination.
Yeah.
But I may have got this completely wrong. I thought that Ms. Hill had said that in relation to age discrimination, it's direct discrimination that they're talking about.
It is, which is why I put it down as a flag. The analysis of Lady Hale in SG plainly does not apply to direct discrimination, because in direct discrimination you're actually producing a measure which is targeted at a group with protected characteristics, if I can put it in the simplest form.
Yes.
The contrast that Lady Hale was drawing in SG was between that situation and the situation that we may or may not find ourselves in, which is why the strangeness of the analysis about discrimination in our particular case on sex discrimination may be interesting. But assuming you get over that and assuming you are in a case involving indirect sex discrimination or race discrimination or any other sort of discrimination, the contrast is between a measure which is targeted, brackets direct, and a measure which by definition, because this is the definition of indirect sex discrimination or discrimination of some other kind, where you have an apparently neutral measure.
Yes.
So you're not targeting the women, you're not targeting people of a particular race, whatever it may be. You've got an apparently neutral measure, and it just happens to have disparate effects or disproportionate effects on one group which has protected characteristics as compared to another group which doesn't. And in that situation, says Lady Hale, kind of by definition, you're not looking at the targeted type of discrimination, in our context age, you're looking at a measure which is not designed to affect a particular protected group. So your focus should be, in terms of justification, on the justification of the measure itself,
I see.
because it's advisedly not designed to create a difference. That's why I say it's slightly weird here, because when you get to sex discrimination, for reasons which will become apparent in a second, there's a pretty decent school of thought for saying it's either direct discrimination or bust. But if you are in indirect discrimination, I simply put down the marker. I only put it down not to try and raise unnecessary complication. That's the very obverse of what I want to do. But just so you're aware that that line of thinking is out there.
Thank you.
Can I just raise something, which is that I think you said, and I see this point, that the comparison for age discrimination has to be, or is at least as put forward by the claimants, between them and between older women born before 1950. But the thrust of Mr. Gilchrist's evidence seems to be showing a difference in wealth or other factors as between women born after 1950 and women born later rather than earlier.
I thought he was a bit broader than that, in the sense that he was looking at those various possible metrics over time.
I see.
I think it was a broader analysis in fairness to him, which did include, as it were, those trends applying as history moves on, rather than being. And I think, in fairness to him, he wasn't trying to do it as a sharp and direct thing.
No. But you say, I think, that the correct comparison for the purposes of looking at the discriminatory impact in terms of age is between women born after 1950 and women born before 1950.
Yeah.
But then would you say that the evidence shows that this group of women is certainly not worse off than older women who presumably would have suffered the same disadvantage in the workplace, etc. But as you say, if one then follows through, one sees that actually these things aren't linear in terms of age. The metrics go up and down because of other social factors. Would that be right?
Well, I think that is an entirely fair way of putting it. And I think that the punchline for present purposes may be that although it isn't intended to be, as it were, a direct and pure comparison, the themes and the progressions, and despite their fluctuations for obvious reasons, are relatively constant and include material which could be useful when doing the comparability that we're talking about on age discrimination.
Doesn't it go a bit further than that? I'd have to go over it again, and I'm not inviting you to, but surely there are passages where he is effectively saying that the cohort, the claimant's cohort, has advantages over the older cohort. It may now be having to face pension equalisation, but earnings opportunities have been better. Life expectancy is better than for women 10 years older. And that's what one would expect.
Yeah.
And I think that is part of what he says.
Well, it is, and I don't think, in fairness, unless I misunderstood her, I don't think Lady Justice Rose was saying anything different. I think her point was the slightly narrow one, if I understood it correctly, which is it, as it were, limited to that. I think we all agreed that that set of comparisons, however the metrics work, do involve an ability at the end of it to do exactly what my Lord has just described. I think my lady's point was simply, does it go on and how sharply was he looking at that?
Yes,
is that-
but the points that you make about defined benefit versus defined contribution, occupational pensions, and getting onto the housing market, I think those were more focused at younger women rather than the earlier pre-1950s group.
They were, and as was picked up in an earlier question, I think one of the metrics I gave you ran from 1966 backwards or forwards, I can't remember which. So that's how I understood my lady's question. So I think the answer is that I can be allowed to agree with both of you.
I think one of the difficulties which I sought to highlight yesterday in questions to Miss Hill was that the claimants themselves have very much put their case on the relative disadvantages that they have with younger women and with men. That's the problem, and so that, in a sense, that's where the focus has been, whereas in relation to age discrimination, as Miss Hill accepted, actually that isn't the appropriate comparator. And so I think that that's one of the difficulties in this case, that the focus of the complaint has not in fact been to say we're in the same position as pre-1950 people, but to say we're grossly disadvantaged as against later people, and so we should be getting some sort of assistance in relation to that. I think that's where the case, in a sense, has got slightly off kilter.
Yes, and I'm not going to, unless you wish me to, I'm not going to go back.
No, I just wanted to mention that. That was all, because it's relevant to this discussion.
Yeah. Also, you said indirect sex discrimination, if I may. There's one pure EU law point, and the submission is that it is not within EU law because it's excluded by Article 7 of the Social Security Directive, which you have behind tab 4 in bundle 1. I don't invite you to turn it up. That's dealt with in the judgment between paragraphs 57 and 64, and in our skeleton between paragraphs 23 and 27. And the relevant bit of the Social Security Directive is, as my learned friend Mr. Straw correctly noted, Article 7.1a, set out in the judgment of paragraph 59, and it excludes, we submit, state pension age, brackets, the determination of pensionable age, the scope of the directive dealing with unequal treatment in matters of social security. And that covers both the actual state pension age and other matters that are, quote, necessarily linked to that difference. That's the EOC case behind tab 6 in bundle 1, paragraph 20. And the principle covers method for equalising, which is here said to create gender discrimination. And the claimant's case, the appellant's case, in a nutshell, is to say that you have to read Article 7 as if the exclusion was solely of unequal state pension ages and as not excluding equal state pension ages. And we submit that that is, first of all, hopeless on the ordinary meaning of the language. It plainly applies to exclude state pension ages generally, and it's impossible to read it as they do. Secondly, there is no, to use the longer word that the EU system appears to use for purpose, there's no teleological support for that. The aim is evidently to take pension ages out of the reach of the directive, and it simply cannot, we submit, sensibly have been intended to create the situation which, if you take up the Divisional Court judgment and go to paragraph 64, and you go to the second half of paragraph 64, it cannot have been intended to create the situation there described. So just to remind you, it's really the bit I had in mind is really the bit beginning with the line halfway through paragraph 64 of the judgment, beginning Article 1 in brackets, and it's the sentence after that to the end, to conclude with the maintenance. Can I just invite you to refresh your memories of that passage? And the submission is that they were right to conclude that it cannot have been in that situation. For para 64, the line beginning halfway through Article 1 in brackets, and it's the sentence that follows that to the end.
I suppose an answer to that might be that what the Divisional Court says is fine if you're talking about consequences of the process of achieving equalisation. But I think it is part of the plain case that in a sense the link with equalisation is accidental. Their real complaint could in principle occur just as much if pensions had been equal from the start, because their complaint is that it's discriminatory to have the same, indirectly discriminatory, to have the same pension age for men and women in this group because of the peculiar needs of women in this group. Now, you may have all sorts of things to say about whether that substantive argument would have any chance of success, but it is, I think, ultimately the substantive argument. And if so, it's not a consequence of the process of achieving equalisation. It's a self-standing point which would arise whether equalisation had been necessary at all.
Well, I'm not sure that's necessarily right, is it? Is it not right because it plainly is linked and was linked to the process of equalisation in the sense that even if they are right, and the logical consequence may well be as my Lord described, but even if they are right, they made no complaint when there was a disparity between 60 and 65, between women at 60 and men at 65, and because they said, and the fundamentals of their case involved the proposition that, as it were, that disparity, that direct discrimination against men and in favour of women is a necessary feature of achieving actual equality, leave aside all the flaws in that, but that position only alters when you equalise.
Yeah, I see.
So it's connected to the equalisation in that way. It's beforehand, the difference about which they complain, they say, is fine and necessary in order to correct the otherwise societal and economic inequalities that exist within society, about which I'll have something to say in a moment. And that position alters and is therefore, for this purpose, directly related to equalisation. Because when you put them all together and it becomes 65 for everyone, the indirect discrimination pops up its head. That's how we put the answer to that.
Thank you.
So that's the second point, no teleological support, which is really the guts of it. And the third point to make is that there is no support, we respectfully submit, in the case law to be found for my learned friend's submission. The Richards case in particular involved a wholly different situation. There's nothing to suggest that Article 7 was restricted to a situation when you have different SPAs only. There's no necessary link to pension age, simply another form of discrimination separable from pension age, their gender, based on gender reassignment. Here the discrimination asserted is precisely about, for the reasons we've just been discussing, and flows on their case from the pension age. So
Well,
Richard doesn't help them, and see, therefore, for that purpose, the correct analysis of both the Richards case and the other case, which my other friend didn't refer to, but did refer to below, the EOC case in the judgment at paragraph 65. So the short submission in relation to those cases is that they were correctly analysed in paragraph 65 of the judgment.
Well, I think Mr. Straw's point about the Richards case, which is, of course, as you rightly say, actually not to do with pensions at all, really. It's quite a different sort of issue. Is that what is clear from that, he says, is you don't read Article 7.1a literally that you have to give it a purposive content. So the paragraph in the judgment, which is at tab 9, which he concentrated on, was where it says discrimination contrary to Article 4.1 of Directive 97.7 falls within the scope of the derogation provided for by Article 7.1a of the Directive only if it is necessary in order to achieve the objectives which the Directive is intended to pursue by allowing member states to retain a different pensionable age for men and for women. I think that was the point that he was emphasising, that is a purposive interpretation and a restrictive one and not a literal one.
My answers are the same. My answers are you've still got, whatever approach you take to purpose, you've still got to go to the ordinary meaning of the language as your prime point of interpretive analysis. You do apply purpose, but the aim of it is evidently to take pension ages out of the reach of the directive in that way, if you're dealing with pension, pure pension, as compared to the sort of issues they were dealing with in Richards. And there is nothing in Richards to suggest that any of those features should lead to a different answer in relation to Article 7, where what you're actually doing is to equalise state pension and therefore to remove direct discrimination on any view that used to exist previously.
Thank you.
Now, if that's the pure point, that's the pure point on EU law, there is then a point which is common to both EU law and to ECHR law. So, in accordance with the court's directive, I've got to focus on the ECHR part of it, but the analysis is essentially the same if you ever get to the rest of the EU law bits. And the point is, or the submission is, that there is no discrimination. The starting point for that is that the judgment at paragraph 70 rejects direct discrimination for clear reasons, and that is not renewed as a point, and deals with indirect discrimination at paragraph 71 to 73. And on proper analysis we submit that there is no indirect discrimination here under the ECHR. The first and perhaps obvious and core point is that the fundamental purpose of the provisions is to equalise the position between the sexes. In other words, positively to remove discrimination between the genders. On their case, the state, in effect, has directly to discriminate in the state pension age, or at the very lowest, something directly related to that in the form of another provision of benefit in order to deal with the indirect discrimination that is asserted. So you either perpetuate the SPA difference, the state pension age difference, on that case, or you pay medical benefits in lieu, but only to women. So you'd have direct discrimination, but in a slightly different way. The focus is principally on the fact of an equalised state pension age at 65 or 66 for this purpose. And the claimants say, as I understand it, that women born in the 1950s are economically disadvantaged compared to men, and then they say that they therefore need a state pension age that is different from and lower than men's. So they say equalisation itself to 65 or 66 is indirect discrimination. And the problems with that, we submit, are myriad. The first problem is that indirect discrimination involves a measure which is apparently neutral. And our first submission is that this measure is not an apparently neutral measure. It does not affect men at all. It is advisedly changing the rules for women in order to correct previous inequality. And a measure which is applied only to one gender cannot, in principle, we respectfully submit, be indirect discrimination. If it's discrimination at all, it must be direct discrimination. you'll recall the James case, the James and Eastleigh Borough Council case, the swimming pool cases, you'll remember where the charges were tied. I see my lady nodding, but the very famous case to do with charges being tied in that way to state pension age. It's in your bundles if you need it, at tab 20, which is in bundle 1. But the relevant passage is the passage in the speech of Lord Bridge at 766 between A and B. Perhaps it's sufficient for present purposes just to read out what he said. The question of indirect discrimination under section 11B of the then 1975 Sex Discrimination Act arises only where the requirement or condition applied by the alleged discriminator to a person of one sex is applied by him equally to a person of the other sex. Pensionable age cannot be regarded as a requirement or condition which is applied equally to persons of either sex, precisely because it is itself discriminatory between the sexes. That's essentially the point that we make. If anything, it is direct, but they don't run direct, the appellants. And they don't run that, no doubt, because if they did, they'd have a fundamental problem of the kind identified in the judgment at paragraph 70. In effect, a requirement to perpetuate direct discrimination in the state pension age for as long as there was some species of disadvantage, I put that deliberately for reasons which will become apparent in a second, to women. That's the first problem. The measure is not an apparently neutral measure. Secondly, when you make an indirect discrimination claim, you need to analyse the extent to which persons with the claimant's protected characteristic, here sex, are placed at a disadvantage by the measure in question. And Lady Hale's speech in Essop, tab 38, bundle 3, at paragraph 26, makes precisely that point, that the disadvantage must be caused by the PCP on which you rely. And you make 3 short points in relation to that question, that causal question. Firstly, the disadvantages of which these appellants complain, employment rates, lower average income, greater part-time rather than full-time working compared to men, and so forth, all the matters carefully set out in Miss Stewart's statement, are not caused in any real sense by equalising the SPA. They existed before, and they exist, if right, after equalisation. They may be social ills, but they are not caused by the state pension age in any real sense. So we have to say that it amounts to indirect discrimination not to use a particular mechanism, here the state pension age, for correcting a disadvantage caused by other things. But that runs into the second point, and the second difficulty, which is that the fundamental aims of state pension are to avert poverty at older ages and to ensure that persons receive back from the state a decent replacement income in retirement on the basis of the NI contributions they've made. The state pension is not designed to equalise outcomes between men and women. More broadly, and particularly given the helpful analysis of Lord Hoffman and Carson about the interlocking nature of social security provision, why is state pension singled out? Other social security measures paid at the same age are paid at the same age or on the same basis to men and women. They likewise do not correct the inequality or disadvantage identified. I could put the same point in a slightly different way as I think my lady put it in discussion yesterday. This isn't a means-tested benefit aimed at alleviating poverty. It might be thought that state pension credit is there to deal with pension poverty. State pension age is applicable to all, to rich and to poor alike. And it isn't indirect discrimination on the basis that it's not used as a mechanism for social engineering to correct broader inequality or disadvantage with other causes. And also one can assume that state pension age had always been 65 for both. Nothing then is caused by the state pension age, but on their case there will be discrimination, or maybe discrimination, for as long as the utopia of economic equality, by any and all measures, is still a future dream and not a present reality. And the third short point to make goes back to Mr. Gilchrist 131 to 174. All of the above, all of the first 2 points, is on the premise that the basic premise which they advance works. In other words, they are significantly disadvantaged, but as I pointed out earlier, that simply throws up a host of questions about the metric or metrics that should be used that are said to trigger the need to then use the SPA specifically as the tool for correcting inequalities of a historic nature. And my respectful submission is that there is, at the very least, really significant complication with that basic premise for all the reasons set out and analysed.
Well, it's Mr. Gilchrist saying that it's complicated even as between men and women of the same age, rather than as between women of different ages.
My lady,
I'm sure that Mr. Gilchrist goes so far as to say it's not possible to say that women are disadvantaged in the workplace even now compared with men. I don't think Mr. Gilchrist would be able to maintain that.
well, he wouldn't, and I don't want to overstate the point, as I tried not to when I was dealing with his evidence earlier on. You're right that in relation to parts of it, the comparison between men and women continues, as it were, and would be to the women's disadvantage. But there are at least some monikers that are specific to women that are advantageous, that he does point out as well. So one perhaps needs to be a bit careful about the bits one's focusing on. For example, longer life expectancy on average, which is obviously a point of some little significance in terms of state pension age. But I fully accept the broader point my lady puts to me, which is that there may need to be, as it were, a slightly different set of spectacles on. If you look at his evidence from the perspective of this sort of discrimination, rather than age, if that's the broader point, I accept it.
Sir James, forgive me, I just didn't note down accurately what you said the basic premise was, which you were then saying was so problematic.
The basic premise is that there is truly a disadvantage by comparison. I think it's at that point that my lady hauled me up entirely correctly, and so we may need to look at that Gilchrist evidence slightly differently if it's men versus women that you're looking at as opposed to age groups.
Yeah,
and I accepted it.
Thank you, very helpful.
I accepted the whole lot. So that's it about the state pension age and its equalisation. If it's about the method of equalisation, in other words, the tapering and all of that, my respectful submission is that precisely the same points arise. There was a question just before moving briefly on to, swiftly on to justification. There was a question about the pool. There was a pool point. I'm not sure how much this is still going to matter terribly, but there was a pool point that was made. And my very brief submissions in relation to the pool point are that the pool must be the pool of people affected by the legislation. And the measure does not operate to the particular disadvantage of one group over the other group. The comparison simply doesn't work because men are not affected at all. The disadvantage relates to broader socio-economic position or positions, if anything. But the problem with that is the one that I've identified, which is that it isn't tied to the measure at all. The measure is about equalising state pension age, not about correcting historic or continuing broader inequalities. So those are the points we made about discrimination. Unless there are further issues on that, can I turn to justification?
Thank you.
And again, I focus on justification under the ECHR for obvious reasons. And it's at this point and in relation to this ground that the debate, as it were, about JD arises. JD in the UK, the recent case. And they say that a manifestly without reasonable foundation isn't the proper test for sex discrimination or a claim of that kind on the basis of JD. my submissions in relation to that, in answer to that, are that there is no argument, I think, that manifestly without reasonable foundation remains the appropriate test as a matter of precedent. DA is binding authority, and we would add so is Humphreys, so is the passage from Lady Hale quoted in JCWI from Humphreys. Binding authority that manifestly without reasonable foundation is the correct test, including in relation to claims of indirect sex discrimination, with which the passage from Lady Hale's speech in Humphreys, quoted in JCWI, let me just give you a paragraph, people will tell you. It's JCWI, and it's the quotation at the end of paragraph 129 in Lord Justice Higginbotham's judgment, where Lady Hale said in Humphreys, seems clear from Steck, that's Steck in the UK, the normal strict test for justification of sex discrimination in the enjoyment of convention rights gives way to MWRF in the context of state benefits. So there's binding authority both in DA, which put the whole debate, the broader debate about MWRF, let there be no further talk about it, or whatever memorable phrase Lord Wilson came up with, and from Humphreys, binding direct authority from the Supreme Court, and that really is the end of it. Second point, even if JD applies, it doesn't suggest, even on its face, that the appropriate test here is anything other than MWRF. It says, at most, that the MWRF test applies to, quote, from paragraph 88 of JD, circumstances wherein the most difference in treatment results from a transitional measure forming part of a scheme carried out in order to correct an inequality. Very hard to see a better description of what Parliament was doing in relation to the measures it took to equalise the historic direct discrimination that had been built into the state pension page. Thirdly, and in any event, as JD, we would respectfully note, is a chamber judgment, and we will be submitting in due course, no doubt, that it misunderstands and misapplies previous Strasbourg, including Grand Chamber authority. There have been plenty of cases in which the European Court of Human Rights has applied MWRF in the context of these sorts of measures outside pure transitional provisions.
Well, now, how analytically does that fit in? This is on the basis that you're wrong on your two previous points. In other words, that JD is binding despite no precedent issue, and that it can't be distinguished on its facts. How does this third point apply?
Well, we would invite the court, not I suspect this court, because we're not going to get there, I'm hoping, but I would be inviting the Supreme Court to enter into dialogue with Strasbourg, a la prisoners voting, in accordance with all the principles that you'll be very familiar with, Manchester City Council and Pinnock,
Yes.
take account of all of that.
Yes.
It's right to point out that an application was made to move JD to the Grand Chamber, which was turned down by the committee at 5, but we would nevertheless still be inviting the Supreme Court not to conclude, as Lord Roger famously put it when we've been back twice in the context of closed evidence, argenteratum locutum.
All right.
But in any event, it's quite a long way down. And my Lord asked me yesterday, are we content, I think was the way you put it, and I accepted that we were, if I'm allowed to be content with the judgment of the Court of Appeal in that way, that we were content with Lord Justice Higginbotham.
Yes.
analysis in JCWI. Do you have that to hand? I wouldn't mind just briefly showing you a couple of paragraphs in it, just to make it clear what you did.
Certainly.
Mr. Chair, give me a moment, James, because I only have it.
You only have it on the electronic, do you?
Yes, I'm not as handy at finding that, but I will find it.
If you need a reference, shout, I'll give you a reference. But
Give me a moment, I'm sorry.
I think we sent it to you, so it'll either be from Mr. Milford or it'll be from, if you're looking on emails, or from GLD.
Okay, that, because it comes by my clerk. So,
Sorry.
but don't worry, I found it yesterday without too much trouble. I'm sure I'll find it again.
Anyway, so far as this court is concerned, it's your first 2 points.
I have it.
So far as this court is concerned,
It's really your first 2 points.
yeah. If you're looking at the JCWI judgment,
Yes.
can I just invite you to sideline, because you didn't have the benefit of that when we sent it, I think. 128. It follows his earlier analysis of DA and Carmichael and all of that. Then the Humphreys quote, Lady Carroll, is 129. With the note of caution in 130 that says you've still got to look at it with some care. Then JD and A and the United Kingdom is picked up in 132 with the citation referring to transitional measures as you see in 132 Roman 1. The precedent point is 1331. The broader point which says, because the argument that was made in JCWI is it only applies in social security cases. Well, we fall within that category anyway, so it may not matter terribly, but the reasoning at 133 Roman 3 and 4 is addressed to that submission and rejected on the principal basis that the principal underpinnings for a wide margin extend beyond state benefits, and James, the United Kingdom, referred to in 1332, was outside the welfare benefit context anyway. And so he reaches the conclusion he does in 134. And then in 136, I think he thoroughly agrees with himself in Akbar at 136. Which is effectively to say, well, it's all relative at all points of the analysis. It's relative in terms of how much margin you give under manifestly without reasonable foundation. And if you're looking at the other side of the scale, your margin may shrink if you're dealing with a suspect category, which includes, we fully accept, sex.
You're not challenging what Lord Justice Higginbotham says in Akbar and repeats in JWCI.
Well, we're not. We note a little bit of caution, which is that we're dealing here with indirect discrimination. So you haven't got a targeted measure. And if all things are truly relative in the analysis, it might make an enormous difference, or it might make a very significant difference if you're dealing with not merely a suspect category, but a measure which is targeting and therefore is direct discrimination. I think it was a point that my Lord flagged in a slightly different context yesterday. Isn't he there talking about, or isn't there a potential distinction between, on the one hand, a measure which does directly target on the grounds of sex, and a measure which is merely indirectly discriminatory, as it were, because it creates different effects? And we respectfully submit that there is some force in that. I don't think it's been explored through, but one wants to be a bit careful in taking only one part of Lord Justice Higginbotham's analysis, and I'm sure we'd be the first to say that he wasn't actually thinking about those sorts of issues there, but there is that point. But perhaps a more interesting or fundamental point is that even if you are in a context where you are dealing with a margin which is narrower because you're dealing with a suspect characteristic, the dominant feature of this analysis, I submit, is that he is still applying correctly a big broad margin based on institutional competence and democratic accountability. And one sees that in particular from paragraph 140, and effectively says so in terms in 148 Roman 4, dealing with the Humphreys case. My lord, my lady, that's all I wanted to say about justification and the test. I don't know whether my lord or my lady wanted to have a break, but if you did, it might be a bad place to do it. I've got justification on the facts to deal with, which I'm going to be very short with because I've made most of the points already, and then I've got notification and a very short set of submissions on delay. So I will be done by lunchtime at latest, I would thought.
What, even with a short break now?
With a short break now.
Well, then let's do that. We'll have a short break now, and we'll reconvene at 12 o'clock.